Hello and welcome to The View from Mayer Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It's presented by Nicholas Robertson, the head of Mayer Brown's London employment team. This podcast is available via iTunes, YouTube and the Twitter feed Nicholas Robertson, Twitter handle @NicholasRobert11. It is also now available on Spotify, Google Play and Yahoo. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions.
Hello and welcome to podcast number 177. This isn't the podcast I expected to give. I had originally said that I would do one on handling collective consultation issues. I am going to do that. It's just going to be podcast number 178. This is designed to be a relatively short one after the rather lengthy podcast that I did last time round, because we've got some further guidance on what I think is a key issue in return to work, and that's workplace testing. And in particular, what are the data protection aspects and data protection issues that you should be thinking about in connection specifically with workplace testing. And it's a question that's come up a fair amount already. Well, we've now got guidance from the ICO published this week on the subject of workplace testing. It's relatively short. It's very clearly written, and I thought it was worth just saying just a few words on the subject. The clear impression you get when you read this guidance note is that the ICO is keen to make clear that data protection is not going to be seen as a barrier to sensible and to appropriate measures being taken by employers to protect the health and safety of their workforce. As such, I think it's noteworthy that the tone of the guidance is very measured, seeks to facilitate appropriate testing and safety measures rather than putting obstacles in the way. This is exemplified. The introduction itself to the guidance note states, quote, "Data protection law does not prevent you from taking the necessary steps to keep your staff and the public safe and supported during the present public health emergency, but it does require you to be responsible with people's personal data and ensure it is handled with care," unquote. Then the guidance note then goes on to set out a number of key points to be considered by employers. Generally, it's permissible to process health data about COVID-19 if is necessary for the purpose of carrying out the obligations of the employer, which in this case we're going to be presumably looking predominantly at the employer's health and safety obligations. And the employer must, if it's going to rely on the need to comply with its health and safety obligations as processing health and safety data, it's going to need to make sure it has the appropriate policy document in place before it does this. And that's the standard document expect, explaining data control procedures for securing compliance with personal data processing principles. So employers are encouraged to do a data protection impact assessment in order to ensure that the testing, or whatever it is they're doing, but ensuring in this context the testing of employees is appropriate and compliant. As is normal, the assessment, the data protection impact assessment, looks at what you're proposing to do, the data protection risks, and whether the testing and then consequent processing is necessary, and whether proportionate safeguards have been implemented to enable the data protection guidelines still to be complied with. The guidance note makes the point it's obviously important to avoid collecting unnecessary or excessive information. And the example given in the ICO guidance note to illustrate this is that knowing what the outcome of the test is, do you or don't you have symptoms of the virus, may be important to the employer. Information inadvertently gathered about underlying conditions doesn't need to be retained or processed. It's also important, according to the ICO, to retain a record of the date of any test results, given that employees' health may change over a period of time. The guidance note doesn't say this, but presumably there will come a point when there is no need to retain those test results. The ICO guidance accepts that it will be appropriate in some cases to keep lists of employees who have symptoms of the virus or have been tested as positive, but to ensure that the use of such data is necessary, relevant, and for an appropriate purpose. It's easy to envisage, for example, that information on who has or has not tested positive may become utterly irrelevant after a period of time. And the guidance note focuses on the need for transparency with employees, and the employer should be clear, open and honest with the employees about what it is doing and how it proposes to use the personal data. Whilst this is obviously an important point generally, it's particularly important, I'd suggest, with health information. At a minimum, employees need to know what personal data is required, what it's going to be used for, who the employer will share it with, and for how long that information is going to be kept. And I think, really, all of this needs to be seen as part of the aspect that I keep banging on about, which is the need to inspire confidence in the returning workforce means the need to consult and communicate super clearly and be willing to listen to concerns and objections as well. Because if employees understand why this is important, what's going to be done with it, then the whole thing becomes much less scary. Otherwise, a policy like this is just going to create, a policy of testing will just create more aggravation and confusion. One of the specific questions, and indeed I think I've spoken about this before, is whether if someone has tested positive, can that result be shared with other employees? And clearly the purpose of testing is to see whether employees have indeed got the virus. So to that extent, this is a question that's going to become even more pertinent. Well, in line with the previous guidance from the ICO, the note says that it is permissible to notify staff about potential or confirmed coronavirus cases. The note continues to state, as it did previously, in the previous version, the employer should avoid naming individuals if possible, and the employer should not provide more information than is necessary. The ICO confirms that data protection does not prevent the employer doing its duty to ensure the health and safety of all its employees, and so in this context, the note broadly states there are many routes available to share data using conditions and exemptions under the Data Protection Act 2018. Since this comes immediately after flagging the employer's duty to ensure the health and safety of all its employees, it may well be that the ICO envisages that employers rely on health and safety obligations as justifying even the disclosure of the identity of an individual who is affected in certain circumstances. My personal view is that it may well be acceptable to disclose an individual's name to people who have been most directly impacted by virtue of having been in close contact with that individual for a prolonged period and in close quarters. That may be very sensible, enabling individuals to evaluate risk, who in turn may also have come into contact with that individual, and so on. But I think if you are taking that step, you need to be clear you are taking an extra step by naming the individual, and you should probably only disclose it on a strictly need-to-know basis and against assurances that the individuals concerned to whom it is told will respect the need for confidentiality. There's also a section in the guidance on whether it's appropriate to use temperature checks or thermal cameras on site as part of a testing program or monitoring of staff. The ICO points out, of course, this is more intrusive technology. So again, it's important to be clear about the purpose and context for the thermal imagery. Why is it necessary to obtain the information in the first place? Why is it being obtained through these means? It's also important, according to the note, that employees are fully aware of the existence of the information that has been gathered, how it's been gathered, and what it's to be used for. Same point, really. It's also appropriate to think about whether the same results can be gathered through less intrusive means. But subject to that point, it does seem that there is no insuperable problem for employers, according to the ICO, who want to use such technology, provided they go about it in the right way and with the appropriate communication to staff. I am quite sure that's not last word on this subject. I'm sure there will be follow-up. I'm sure there will be some case law created at some point. But for now, it does seem as if the ICO is keen to be seen as helping without abandoning its principles, of course. So, as I always keep saying at this point, stay safe, everyone. And until I do the next podcast, I hope everyone remains well and healthy. Take care, all. Bye.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions or want to know how to claim continuing education credits, please email Nick at nrobertson@mayorbrown.com. Thank you for listening to the podcast.